I just wanted to do a brief video for some people who have asked questions regarding motions to lift detainers because of COVID and motions for reduced bail or nominal bail because of COVID. It's important to understand that there's a lot of rumors floating around that people are being released from jail simply because of the COVID epidemic. And while that's true in some cases, in many cases, and our law firm has handled a lot of these cases recently, the court's going to require a motion from your attorney. Now, right now, our firm has been working on these pretty much exclusively because all other areas of our practice are shut down. We're only appearing in these types of hearings and for bail hearings, which again are occurring 24 hours a day, 7 days a week. So getting back to COVID motions and motions to reduce bail or lift detainers based on COVID. It's important that when you file the motion that your attorney cite very specific constitutional grounds for the motion. It's necessary to cite the 8th Amendment to the United States Constitution. If you're in Pennsylvania, you're going to want to cite Article 1, Section 13. If you're in New Jersey, you're going to cite Article 1, Paragraph 12. That'll provide the basis for the release. Now, it's your attorney's job to tie the law in with the facts of your case. Now, obviously, the COVID epidemic is the underlying theme here, but I wouldn't rely simply on that because obviously people are going to be in jail regardless of COVID. So the jail's not letting everyone out. Don't assume that you're going to be let out simply because of the COVID epidemic, especially if you're in a situation where there's a state or a county detainer against you for a probation violation of some sort. It's important that you don't assume that you're going to be released. If you have an underlying medical issue, it's important that your attorney put in that motion what the issue is. If you're taking medication. Now, obviously, I would not suggest contacting your doctor and having them do a formal report. Obviously, if there's time to do that, but right now the system is extremely overtaxed. Your physicians and your doctor's offices and your ERs and your hospitals are really dealing with people who need immediate attention. So I wouldn't suggest doing that. What I would suggest is having a list of medications available, what you take, why you take it, how often you take it. And for instance, if you have asthma, how severe the asthma is, if you have some type of medical report, even if it's old, you're going to want to cite that in the motion. Now, your attorney, you may not know this, but as an officer of the court, can represent to the court that they have spoken to you and that based on your discussion, they have reason to believe that this condition could could make you more at risk. Now we're getting in an area now where this is a medical diagnosis, and the judge may kind of look at you with a little bit of suspect eyes, if you will. But again, your attorney can do that in court. But obviously, if you have a list of medications, if you have some medical documentation, it's going to make the motion a little stronger. So if your loved one's sitting in jail, that's something that you want to provide to the criminal defense lawyer who's representing you. If you're contacting our firm, as you're aware, it takes calls 24 hours a day, 7 days a week. We've done a ton of these motions, but again, don't assume you're going to be let out. Please don't listen to the internet and Facebook rumors about everyone's being let out of jail and bail's not even being assigned anymore and police aren't arresting people. These statements are 100% false. They're wrong. The people making them have no idea what they're talking about. They're not lawyers. They may work in the legal system. They may work for judges. Doesn't give them a law degree. They may even be lawyers. But the fact that a person's a lawyer or works for the courts or works for a judge, that doesn't mean that they know how to argue a motion or whether or not a motion is going to be granted. You want to speak to a criminal defense lawyer. You want to speak to a person who's qualified. Again, the motion has to make constitutional sense. You have to give the judge a basis for the release, especially if the detainer is because of some serious crime. For instance, you're charged with a felony offense like a gun charge or a possession intent to deliver, or some type of more violent felony like a robbery or an aggravated assault, even an attempted murder. It's not that you can't be released, but you have to give the judge a constitutional basis for it. Now, in the sections that I cited, the Eighth Amendment to the United States Constitution, Article 1, Section 13, Article 1, Paragraph 12 of New Jersey, these do that. But the judge, it's up to your lawyer to tie in all this for the judge. And also evidence that the person is not a flight risk. Do they have family in the area? Do they have contacts with the community? All that is relevant. I've written blog articles on bail motions. I encourage you to look at those. I've done a blog article on COVID detainers and probation issues. I encourage you to look at that. Again, your lawyer is going to argue a bail motion here, but with a little bit of a spin to it. And it's important that it's done in a proper way. Don't just contact any lawyer. You want to contact an attorney who has a background, obviously, in arguing motions before a court. Don't just find your neighbor who happens to practice real estate law or tax law. Hire a criminal defense lawyer. Before you hire the person, you're going to want to ask them how the motion is going to be filed. Now, in Pennsylvania, in a lot of our courts, we can e-file motions. Most of the counties, with the exception of a couple locally, you can e-file motions. I believe Delaware County is the only court right now that's not accepting e-filings, but the rest of them can be e-filed. And New Jersey, through the e-court system, it's the same way. They can be all e-filed. Also, in most situations, it's not necessary for your lawyer to actually physically go to court anymore. They're doing remote motions. Again, very important. Now, these are questions you want to ask the lawyer: how the motion will be filed, how soon can you get a court date? Now, that's a little bit difficult to understand because every court is a little different. I know that in Montgomery County, they seem to be getting back to us very quickly. Philadelphia is a little better as well. I can't speak for outside the 5 counties. For instance, Lackawanna, Carbon, those counties, I don't know what's happening there. We haven't argued any motions there yet. Obviously, if we're called to do so, we're ready to do it. But I would encourage you to reach out to a criminal lawyer, ask questions. Again, the motion has to make sense, never make an assumption. Finally, just a tip for the day: if you're running a small business and for whatever reason you're choosing to operate, I'm not going to judge anybody here, but just if you're choosing to operate, just know that if police knock at your door, you're not obligated to open up your door. Now, if it's an administrative agency, for instance, the FDA, the L&I, it's a little different. Now, again, I did a previous video on this. I encourage you to look at it. I wrote a blog article on it as well. If law enforcement does enter your premises, do not make a statement. Do not consent to a search. I give that advice all the time, just like you're charged with any crime or you're being accused of a crime. Don't make a statement. Even if they say, well, it's going to make your case better, never make a statement. So for more information, please visit GamboneLaw.com. I hope you're all doing well on this Saturday and you're making just doing the best that you can with you and your family. Our firm is here 24 hours a day. We look forward to seeing you soon, hopefully when all this is over. And I wish you the best, and I'll see you all soon.